Hello everyone, welcome to Legal Darshan. In today's video, we are going to discuss case number 15 listed in the AOR list leading cases. It is case number 15 and this is the case of Roopa Hurra versus Ashok Hurra. So Roopa Ashok Hurra versus Ashok Hurra is the case title. It is a 2002 5-judge bench Supreme Court decision. And in this case, the moot question before the court is that number one, whether even after dismissal of review, does the aggrieved person has any remedy before the Supreme Court of India, and whether the writ petition, whether the writ jurisdiction under Article 32 can be invoked to overrule a judgment given by the Supreme Court if it is found that there is a miscarriage of justice. Now, there is one doctrine that this judgment is also focusing on, which is the doctrine of ex debito justitiae, which we have already discussed, we have already talked about in the case of ARAntulay versus RS Nayak. ARAntulay versus RS Nayak is the case listed at number 5 in the list of AOR leading cases. Now, what is happening in this case? A brief fact of this case goes like that Roopa Hurra is wife of Mr. Ashok Hurra, and in this case she is challenging the finality of a Supreme Court judgment which is granting her mutual divorce with her husband in the exercise of Article 142. Now Roopa Hurra herein is claiming that the consent which she gave for the divorce was obtained by fraud or misrepresentation, and she has also filed a review against it, but that review was dismissed in the chambers. So because she was left with no statutory remedy, because 137 is the last stone that you can turn to establish your case, but even her review was dismissed. So since she wasn't left with any statutory remedy or any constitutional remedy, she is invoking the court's jurisdiction in by way of Article 32. Okay, because Article 32 guarantees that if there is a violation of fundamental rights, one may come to Article 32. Now, the moot question that arises here, that whether an aggrieved person, okay, whether the person, she entitled to any kind of relief, even after there is a final order given by the Supreme Court of India, and the review on the same is also has also been dismissed. The second question that arises is that can Supreme Court, in exercise of Article 32 jurisdiction, reconsider its own finality over one judgment? And if there is evidence, if there is a fact established that there has been miscarriage of justice, can court evolve a remedy to cure that particular grievance, to cure that particular miscarrying of justice? The court herein is firstly saying, number one, that Article 32 cannot lie against a constitutional court's judgment. Okay, because if it lie against Supreme Court judgment, it would mean that court is reviewing its own decision through writ jurisdiction. And if we open that Pandora box, all of the decision that has been given by Supreme Court can be coming under the jurisdiction of Article 32, and no cases will finally get a closure, because it will be a whole new Pandora box of remedy that we will be opening against any or every decision of the Supreme Court of India. So this particular fact was also iterated in the case of ARAntulay versus RS Nayak. So in ARAntulay versus RS Nayak, as well as in this case, the Supreme Court is basically, saying that Article 32 cannot be invoked. The writ jurisdiction cannot be invoked in the form of certiorari or any other relief, any other order to, to quash the proceeding of the Supreme Court itself. Okay, so court herein is saying that neither Article 32 of the Constitution can be invoked only for the purpose of enforcing the fundamental rights conferred in Part 3. And it is a settled position in law that no judicial order passed by any superior court in the judicial proceedings can be said to violate any of the fundamental rights enshrined in Part 3 of the Constitution. The superior courts of justice do not also fall within the ambit of state or other authorities under Article 12 of the Constitution of India. So this was also one of the discussion in ARAntulay, where in ARAntulay we were dividing the role of court in two kinds. One is judicial and one is administrative. So administrative roles, when judiciary is exercising, it may fall in the purview of state under Article 12. But in the case of judicial roles, when it is discharging justice, we cannot say it is a state, because we cannot say that courts themselves are violating the fundamental rights of the individual. And if we, again coming to the same point, if we open that, box that you can come in the Article 32 jurisdiction, there is a high chance that no order, no fine, no order or no verdict will attain finality until the person is exhausting all of the remedies available to him. Now the court herein is looking at that we cannot invoke Article 32, right? But we can reconsider our own judgments in the case of abuse of process or to cure the gross miscarriage of justice. Now, this was something which we also have had a discussion in ARAntulay, that when there is a miscarriage of justice, court may review its own decision. In ARAntulay also, the court has reviewed its own decision and the court has given has overturned the verdict. However, the way the litigation happened is a lot different than it is happening in Roopa Hurra versus Ashok Hurra. Roopa Hurra versus Ashok Hurra is a case arising out of the same transaction, but there the case was arising out of two different transactions. One, when the allegation of corruption was made against ARAntulay, and second, when he was convicted. So the second litigation is happening when ARAntulay was convicted. So there are the various transactions in ARAntulay's case, so the case could not definitely reach to curative petition. But herein we are saying that if all the remedies are exhausted and the court finds that there has been an abuse of process, there is a gross miscarriage of justice, what the court will do. So in this case, the court is redefining substantive justice. The court is allowing substantive justice to overrule the procedure, and court herein is bringing the creation of curative petition. Now, curative petition is premised on the maxim ex debito justitiae. Okay, to balance the finality and fairness, the court should invoke its inherent power, and in exceptional cases, not in every cases, and in exceptional cases where there is gross miscarriage of justice, the court may go back and visits its own judgment even after review is dismissed. So the last remedy that is available in the top court is the review, but this case is creating another petition, kind of petition, which is curative petition. Now the court is terming this whole new petition, whole new way of approaching the Supreme Court as a curative petition. Okay, now how do we understand that where a gross miscarriage of justice is happening? What is the criteria by which it can be ascertained that there has been gross miscarriage of justice? Because because the court in this case is saying that the judges, the highest court, the top courts, High Court or Supreme Court, they do their best, the best of their knowledge, but because to err is to human, it might arise in the rarest of rare cases, in the most exceptional case, that a final judgment has to be set aside to see through the miscarriage of justice that has happened. So for those cases, what could be done? So that is where if the court is herein laying down that if the petitioner or the aggrieved is entitled to the relief ex debito justitiae in the light of justice, in the court's duty to dispense the justice, if he establishes that there has been violation of principle of natural justice, in that he was not a party to the list, but the judgment adversely affects his interest, or if he was a party to the list, he was not served with the notice of the proceedings, and the matter proceeded as if he had the notice, right? And second, wherein the proceeding, a judge failed to disclose his connection with the subject matter of the parties, giving scope for an apprehension of bias, and the judgment adversely affects the petitioner. So basically, if we look at 2.3 and 2.4, we are basically looking at the principles of natural justice. So first principle is talking of that if there is no notice and if the person is not being told that there are proceedings going on, so we are talking here in audio alterum partem, and where a judge is proceeding along with his bias, he is not telling that he has a subject matter bias or any kind of bias, personal bias with him, we are actually talking of rule against bias here. So where there is a violation of principles of natural justice, the petitioner is entitled to the remedy of debito justitiae. This is first, the court is looking at when judicial discretion is exercised, these two remedies are given to the petitioner. In the curative petitioner needs to aver the specific grounds that are mentioned here, that these were taken in review petition and that it got dismissed. Now another thing, how do you file a curative petition? The court herein is laying down some kind of guidelines so that it cannot become the tools in the hand of a grief to challenge the Supreme Court judgment. Okay, so now in curative petition, if your curative petition is if your review petition, pardon me, if your review petition is dismissed, so curative petition can only lie if your last resort has been dismissed. So in case your review petition has been dismissed, you need to demonstrate in your curative petition that these were the grounds that you have also taken before the court in the case of review as well. Okay, so those grounds that you are now bringing in the curative petition, they would have must be raised in the review petition. Now a senior advocate needs to certify that the petition meets the criteria. Okay, it must be established that there has been a violation of principles of natural justice, there has been bias, and some fundamental principles of judicial process are violated. Okay, because it is very exceptional that it can happen. But if it is happening, this is an abuse of process, and the senior advocate of the Supreme Court shall be certifying it, and then the petition shall be circulated to the bench of 3 senior most judges and to the judge who to the judges who have given the verdict. It will go before them, right? So now in the exercise of inherent power of Supreme Court, inherent jurisdiction of Supreme Court, the court may consider what the fallibility was, what happened in the case, and if there is a gross miscarriage of justice, the court may cure it. Okay, so the Supreme Court is the court of last resort. Final question on both facts and both laws, that is declared by the court of by the Supreme Court of India. It sets down the principles for all the other courts to be followed, right? The principles in regard to the highest court has to be followed in all the cases that are being decided in the land of India. Now, these are the few reasons that on which curative petition can be filed. And in this case, the court has looked at one of the most important precedents that was laid down in the case of ARAntulayVsRSNayak. And court is saying here, and the final conclusion herein is that yes, an order passed by the court, by the Supreme Court as well, cannot be assailed in the application under Article 32 of the Constitution of India. But to prevent the abuse of the process and to cure the gross miscarriage of justice, the court may reconsider the judgment. It has passed already in the exercise of Article 142, in the exercise of its inherent power. Okay, so now in this case, what happened, that registry was directed to process the present petitions, and the petition were being processed. The court heard this matter and then laid down the guidelines for the curative petitions to be met. Okay, so this was the case of Roopa Hurra versus Ashok Hurra. The final takeaway from this case is that certiorari cannot be invoked to nullify the decision of the top court of India. And also, when the senior advocate is certifying that there has been a gross violation of principles of natural justice, there is a miscarriage of justice prima facie, even it needs to be circulated before the bench of the 3 senior most judges and the judges who passed the judgment, and when the majority of the judges on to which it is circulated, if they think that it is a fit case to be heard, they can hear it. Otherwise, they'll not hear it. All right, because this is a very rarest of rare jurisdiction, a very exceptional jurisdiction. And if there is no gross violation found, exemplary cost may be imposed on the petitioner also, right? So this was held in the case of Roopa Hurra versus Ashok Hurra. You have to meet the principles of natural justice. A senior advocate should be stamping your case. Also, it should be circulated before the bench, the three senior most judges, and the judges deciding the matter. And if approved by majority, we can go ahead with the curative writ petition. So this curative petition, pardon me. So this was held in the case of Roopa Hurra versus Ashok Hurra. I hope the discussion is clear. ARAntulay is one landmark case which we need to go back to when we are doing Roopa Ashok Hurra also. Something similar is happening, but out of the different context is happening in Antulay also. Judgment is getting overruled also, as we discussed. But the two cases together jointly brings out a large scope of curative writ petition, especially Roopa Hurra versus Ashok Hurra. So this is for this video. Thank you, everyone. I hope the discussion is useful to you. Stay tuned with Legal Darshan. Have a great day.